Hey there, I'm still working on my course on employment law, but the topic I'm looking at the moment is quite small, discreet, and hopefully you'll get a kick out of it, which is why I'm deciding to put it on YouTube as well. And it's all to do with summary dismissal, which you'll often have seen on film or television because it involves someone saying, "You're fired, get out of this office right now," or something along those lines. Now, in the reality of employment law, it's often not as dramatic, but it does still require serious misconduct by the employee for them to be fired on the spot. That can involve things like dishonesty, thieving from the employer, or gross negligence. But in terms of the conduct that actually adds up to this and the in-between type cases, we need to sort of judge each case on its fact and look at some of the case law in this area to try and get a sense for when an employee can be summarily dismissed. So with that in mind, let's get started and get stuck into the case law.
The place where we should start is with the standard of behaviour expected of the employee, and that is the standard of a reasonable person. And for our purposes, when talking about summary dismissal, it essentially means that nobody is perfect and we're not expecting employees to be saints. A really good example of that is the case of Wilson and Racher from 1974, in which an employee swore at his employer. Now, he was summarily dismissed for that, but it was later held that the summary dismissal was unfair because of the conduct of the employer as well. Essentially, the employer had provoked the employee, and the employee, being the reasonable person that they were, got annoyed by this and ended up swearing at his employer. So we see that the courts can take a little bit of a flexible view when talking about employees. So don't expect the employees in your problem questions to be perfect either, and try and think about what you would do in that particular situation, either as the employer or as the employee. Were they acting reasonably? So moving on, there are certain professions that have specific conduct that are not going to be tolerated. The classic example would be that of airline pilots who cannot be drunk while driving the plane, or I think any time really. But there are certain standards expected with certain professions, so make sure that you look out for that. And really anything that's written into the employment contract where it's made very clear to the employee that conduct of a certain type will not be tolerated and may result in a summary dismissal. So what about employees who start rival businesses? Well, this is not necessarily a misconduct itself that can give rise to summary dismissal. The case of Laughton Hawley is quite an interesting one because they essentially set up the business in their own time and used all of their own expertise, and so that was fair enough. Nevertheless, there is a duty of employees to act in good faith and also in the employer's best interest, which is something we've talked about at other parts during the course, and the case for that is Marshall and Industrial Systems Control. And in contrast to Laughton and Hawley, in that later case of Marshall, the employees were using things like their contacts that they had gained as part of their employment to help with the setting up of the new business, and even tried to steal clients from their current employer, which was obviously unfair and not in the employer's best interest, and so that summary dismissal was fair. Now, in cases of gross neglect, there's a sort of a problem that we have to face in this situation, because on the one hand, we could have very small amounts of neglect. Minor neglect could lead to disastrous consequences, and on the other hand, serious neglect could only lead to minor consequences. So the question for the courts is, how do we actually deal with this? What should we focus on? And in the 1930 case of Savage and British India Steam Navigation Company, it was decided that because we're talking about the employee being summarily dismissed, the focus in such cases should be on the actual conduct of the employee rather than anything else. Another relevant factor is also the seniority of the employee, so if they're quite high up in the organisation, then a higher standard of behaviour is expected of them, and so any gross neglect is potentially more likely to be held a fair summary dismissal if the employer decides to follow that course of action. Finally, we need to talk a little bit about strikes. And so for strikes and other disruptive action which is associated with strikes, so things like go slow or working to rule, then that is also a ground for summary dismissal. So it's something to be aware of when thinking about industrial action and any problem question that might come up on that topic as well.
If you do come across a summary dismissal in a problem question, then the effect is immediate and the employee often has to clear out their desk within a certain time period and may even be escorted off the property. If the employee then wants to claim any certain rights that they might have, such as payment for their normal notice period, then they would have to do that through the courts or the employment tribunal. Anyway, I hope that you've enjoyed this video. As you can probably tell from the background, I've moved flats recently, so I'm not really too sure about the plain white background. I might try and do something about that so that you don't have to look at my face while I'm recording. But in the meantime, I'll be continuing with the employment law course, so look out for that shortly. Tune into the podcast as well. Do the whole like, comment, subscribe thing, whatever people say on YouTube. And I'll see you again soon. All right. Bye!